Welcome to Torts, January 11, 2023. We're going to begin with a quick review of negligence, since this is the last area of torts that I understand that you covered last semester. Once we move from the review of torts, we are then going to begin our introduction into affirmative defenses to negligence. We're going to focus on the very first affirmative defense that we're going to cover, which is contributory negligence. And then we're going to go through a case as an example of what the contributory negligence doctrine looks like in practice. Going back to negligence, let's start with what negligence is. Negligence is defined as the failure of one person to exercise the expected level of care as it relates to another person, right? As a result of this failure to meet the expected level of care, the latter person, the second person, the plaintiff in this situation, now suffers an injury, and that injury is causally connected to the failure of the first actor. So that's a lot of this person, that person, first person, second person. So let's start here. Jill has a duty of care, an expected level of care that she is supposed to stay within as it relates to Jack. Jill fails to meet that level of care. Jack is injured, and Jack's injuries are the result of, or the injuries are caused by Jill's failure to act in accordance with the expectations. You have duty, you have breach of duty, you have causation, and you have damages. So again, this is just a really quick review. There is a duty of care that is expected. There is failure to meet the expectations for that duty of care. There's an injury that is caused by the failure to meet those expectations. So we have duty, we have breach of duty, we have causation, and we have damages. Those are the four elements. And let me back up real quickly. I want to make sure that you understand the four elements just a little deeper, right? That duty, that first element, is often created either statutorily, created by regulation, created by societal expectation, okay? The second element, which is breach is defined as, according to the perspective of a reasonably prudent person in the defendant's position, the defendant failed to use reasonable care to avoid a reasonably foreseeable risk. So I have a duty, which is that expectation. I have a breach, which is the failure to reach the expectation. And then I have causation. And we're going to slow down just for a minute here on causation. And the reason we're going to slow down here is because I want to make sure, and I am confident that your previous professor went through this ad nauseum, right? So bear with me. Just want to make sure that as we talk about causation, there's a clear understanding going forward that causation has two conjunctive prongs. What do I mean? Two conjunctive prongs. I mean, two prongs that must be established in order for liability to attach. You have to establish cause and fact, also known as actual cause, and you have to establish legal cause, also known as proximate cause. Cause and fact, aka actual cause, can be established by one of two tests. So let's go back. Causation, two mandatory prongs. First prong, actual cause, also known as cause and fact, has two ways, one of which you must use to establish. One test for cause and fact is the but-for test. The second test for cause and fact is the substantial factor test, right? The but-for test is the test that looks to determine if the act or the omission that is the breach of duty, if it would not have resulted, excuse me. The but-for cause is the act or omission that caused the breach of duty, but for that act, we wouldn't have an injury. But for that act, we wouldn't have an injury. So it's literally but for, okay? That's one way to test for cause and fact, also known as actual cause. The second way is the substantial factor test, and that's where the court is going to consider whether the defendant's actions were a substantial factor. So when you're going through your analysis and you get to the third element of negligence, which is causation, you need to make sure that you lay out that there's an actual cause and a proximate cause. If you prefer to use the language cause and fact and legal cause, that's fine. Just make sure that you don't get those two mixed up. As you set out your actual cause, you need to make it clear to the reader that you are aware that there's two tests that can be done to determine whether or not there's an actual cause. And you only have to choose one of the two. So let the reader know which one of the two that you're going to choose. Now, turning to the legal cause or the proximate cause, this is the area of the analysis where you're looking at the foreseeability. The foreseeability of what? The foreseeability of the plaintiff's injury. Well, the foreseeability of the plaintiff's injury based upon what? Perfect question. This is your causal chain. I'm a very visual person, and so I might actually create a chain. What are those sequence of events that have to occur that link us from the breach of duty, right, to the injury? So what links us from the breach of the duty to the injury? If there's two links, then both of those links need to be tested for foreseeability. If there's three links, then all three of the links. If it's four links, then all of the links, right? So for instance, if I were to dump toxic waste in the ocean, that waste washes up on the beach, and a beachgoer pricks their finger on a piece of sharp glass that was part of the toxic waste that I disposed. What you have to do is look at what steps were taken from my breach to the injury, identify them, and ask the question, if this happens, is it foreseeable that there's going to be an injury? If Washington dumps this toxic waste with broken beakers and broken glass syringes and all other kinds of equipment in the ocean, is it foreseeable that the plaintiff is going to get injured? Yes. Is it foreseeable that whatever I use to put the waste in to dump it might break? Yes. Is it foreseeable that if it breaks, the content is going to get out? And if that content gets out, there could be an injury? Yes. Is it foreseeable that as that content is floating in the ocean, it's going to land on the beach? And if it lands on the beach, there's going to be an injury? Yes. Is it foreseeable that once it gets on the beach, that it might be able to be exposed to somebody who doesn't know about it? Yes. Right. All of those things in that causal link, in that causal chain, are yes. So ultimately, I get to then me dumping is the proximate cause because all of the chains in the link were foreseeable. Okay. If all the chains in the link aren't foreseeable, then the causal link is broken. And if it's broken, then there's no proximate cause. If there's no proximate cause, there's no liability, because we've already established that in order to be liable, not only do I have to have a duty, not only do I have to have a breach, I have to satisfy both of the mandatory prongs of causation, and then I have to have damages. And so I think that's a fairly good recap of negligence. With that being said, let's move to some new territory. Let's move to affirmative defenses. Now, these are going to be affirmative defenses that are associated with negligence. So basically, what am I saying? If a plaintiff is able to establish a prima facie case of negligence, the plaintiff wins, right? If the plaintiff is able by a preponderance of the evidence, because that is the standard by which the plaintiff must provide, if the plaintiff is able to establish by preponderance of the evidence that the defendant had a duty, that the defendant breached the duty, that the defendant that the cause of the injury that is suffered is because of that breach. Understanding causation has two prongs, and there's actual damages, right? Plaintiff wins. Yeah, we all go home, right? Yep. Bye. Pick up your stuff. Counsel, it's been fun. Your Honor, may I be excused? Yes, you may. Everybody leaves. Skirt. Not quite yet. Not quite yet. Once the plaintiff has established a prima facie case of negligence against the defendant may be able to assert an affirmative defense, thereby allowing the defendant to go unscathed, meaning that the defendant doesn't have to pay the damages for the injury that the plaintiff suffered. So what does this look like? Step one, plaintiff establishes a prima facie case. Step two, the defendant has asserted an affirmative defense, and, right, because it's an affirmative defense, the defendant now has the burden to establish the affirmative defense. Got it? Plaintiff can establish a prima facie case against defendant. Defendant, if they can establish all the elements in their affirmative defense, then even though plaintiff established a prima facie case, defendant doesn't have to pay. So instead of being ethereal and kind of being general in our explanations, let's go deeper and let's get a little more specific. The affirmative defense that we're going to look at first is the affirmative defense of contributory negligence. So, contributory negligence, what does that mean? Contributory negligence means that the plaintiff has also contributed by way of also being negligent. Contributory negligence. If both the plaintiff and the defendant contribute to the cause of the injury suffered by the plaintiff is completely barred from recovery. Okay, contributes. contributes. Think about it, contributes. What is the plaintiff contributing? The plaintiff is contributing negligence to the equation. And if the negligence that the plaintiff contributes is a cause for their injury, then you've got the plaintiff and the defendant now being equally negligent. Not equal in terms of percentage, but equal in terms of both have contributed to the injury. Does that make sense? Okay. Plaintiff comes in, establishes all four prongs by preponderance of the evidence of negligence. Defendant comes in and essentially establishes all four prongs of negligence against the plaintiff. I'm sorry. Now that we have a preponderance of the evidence of both parties being negligent, under the doctrine of contributory negligence, plaintiff may not seek recovery from the defendant. Go into a case and let's walk through the case together. This is a case that you've briefed. This is a case that you've turned in. This is a case that I will grade because, as I explained on Monday, first day of class, I grade briefs. And the reason that I grade briefs is because it's really important for you to know what process you're using to understand this information and process this information. It's really important for me to know if you are developing a process of which you're able to analyze information, because there's a lot of information coming at you and it's coming at you really quickly. And if you don't build, develop, craft a process, you're not going to be able to be successful in any of the areas of practice, let alone torts. So what you're doing, yes, this is torts. Yes, we're focusing on torts, but the process should be a process that you can build and use not only in your other cases, but 3 years from now when you're actually practicing law. So let's look at the Wright v. Norfolk case. As of the second day of class, I still didn't have a book. Not a book. I still didn't have an email. And because I didn't have an email, I didn't have access to Canvas. And because I couldn't get access to Canvas, you couldn't get access to your book unless you spent $200 to purchase the book, which prevents the whole purpose of the program that we have with Aspen and other publishers. So I gave you a syllabus on the first day of class, and that syllabus identifies the cases that we're going to go over on each day up until the end of the semester. Until we can get the book, use the resources that you have through Lexis, through Westlaw, and all the other resources that you have to actually pull the case. So let's talk about Wright v. Norfolk. Wright v. Norfolk. This is a case that is going to give us a working example of what the doctrine of contributory negligence looks like when it's outside of just words on a page, right? Here is the living, breathing version of the doctrine of contributory negligence. Procedure history. Remember, this is the case where the guardian for the plaintiff sued the defendant railway. First thing to note is we have the guardian suing on behalf of the plaintiff. Well, by reading the case, we know that the plaintiff is 36. So why would we need a guardian to file this lawsuit? That's an indication that the injuries suffered were significant, right? That's just a context clue. And as you matriculate through your law school education, you're going to learn to identify and to translate and interpret context clues. And so might as well get started now in your 1L year. The guardians for the plaintiff sue the defendant railway. Trial court enters an order in favor of plaintiff. That's the result of a jury verdict for $4 million. The defendant files a motion to set aside the jury verdict. That's civil procedure. You'll get to it your second year. The trial court grants the defendant's motion to set aside verdict, which means that the verdict of $4 million that the jury came back with in favor of the plaintiff, the judge, in considering the motion to set that verdict aside, has decided to set the verdict aside, which means now that the plaintiff gets nothing. And so the plaintiff appeals. Here we go. What's the issue? Whether a plaintiff is barred from recovering an award of damages against a negligent defendant when the plaintiff is also negligent. That's the question we're trying to answer. Stop and think about it. I've got a plaintiff who has established negligence against the defendant. If the defendant is able to establish negligence against the plaintiff, what happens? Well, if you are in a jurisdiction that utilizes the doctrine of contributory negligence, what happens is the plaintiff goes home without judgment because the plaintiff is now barred. Okay. Key facts. I'm sure you remembered them. I did not put them on a PowerPoint slide because it's too many to list here that won't, right, there's just too many to list here. But let's just go over them real quickly. We have a truck driver who's been a truck driver for some time, who has crossed this railroad crossing several times, so it's very familiar with it and the nuances of it. In fact, had crossed this same track several times, I believe 5 the day before, and maybe even 4 times previous on the day before the actual accident. Now, there's something about the way that this railway crossing is constructed that it's kind of hard to see, right? It's at a turn, or it's on a hump, or it's something, and it's just not real easy to see if there's a train coming in. It's odd, it's weird, not a problem. We know that the plaintiff, Mr. Wright, was able to establish, yeah, the railway did some stuff wrong, right? The railway could have been more efficient and more focused and more deliberate and more intentional on how they constructed the crossing and how they utilize warning systems to protect those having to cross the crossing that weren't trains, right? So there's no question that there's a list of things that the railway did wrong. Not a question. That's not the focus. I'm not trying to prove negligence against the defendant. It's established, okay? But the defendant says, well, hold on a second though. Sure, maybe we were negligent. However, so was the plaintiff. So was the plaintiff, right? And I give some silence there because it's like, wait, what are we doing now? Are we looking at the actions of the plaintiff? Yeah. Are we going to allow possibly the actions of the plaintiff to punish the plaintiff in such a way that the plaintiff doesn't get to recover any damages? That's what we're about to do. So let's look at the actions of the plaintiff. Plaintiff is an experienced driver. Plaintiff is familiar with the crossing. Plaintiff lives in the neighborhood close to the crossing, so has an added layer of familiarity. Plaintiff crossed that crossing 5 times the day before. Plaintiff crossed that crossing 4 times the same day. Plaintiff had the window rolled up, so he really couldn't hear what's going on outside. If there's bells and if there's whistles and if there's train horns blowing, he can't hear it. Plaintiff has windows up tight with loud music playing. Plaintiff didn't look to see if there was a train, knowing that he would have to take extra effort to actually see the train because of how the crossing was constructed. Plaintiff contributed to the actual cause and the proximate cause of his injuries. And because the plaintiff contributed, the plaintiff now is prevented from seeking recovery, right? What was the holding of the court? The holding of the court affirmed the trial court. So the Supreme Court affirmed the trial court's decision in granting the motion to set aside verdict, rendering the plaintiff's award null and void. What was the reason? Court said it's really, really hard for us not to take into consideration the acts, negligent acts of a plaintiff when they were in a position to prevent this injury had they themselves not been negligent. In fact, the court says that this plaintiff was the quote unquote author of his own demise. Got it? Seems harsh, but it's simple from a legal analysis perspective. Step 1, plaintiff proves negligence against defendant. Step 2, defendant proves negligence against plaintiff. If we are in a jurisdiction that recognizes contributory negligence as an affirmative defense, game over, court's done, plaintiff loses because they contributed. Okay? So I got a question. State statute provides that on roads without sidewalks, a person should walk on the left side of the road. Jill, right, we talked earlier about where do these duties come from? Well, sometimes the duty comes from a statute. So here we go. Jill's walking down the road, vacation resort in Australia, right? Friday morning, great deal of traffic coming into the resort. And Jill is walking on the same road that people are coming in and exiting. I just noticed a typo and I will fix that before I post this video. Before I post the PowerPoint. There is very little traffic on the right side of the road. And Jill decides to walk on the right side of the road instead of the left side of the road, okay? Jack is driving on the right side of the road. Jack is participating in a Zoom meeting while he's driving. Jack is not paying attention to the road. He does not see Jill until it's too late. Jack hits Jill. Jill suffers major injuries. Jill sues Jack for negligence. Jack raises Jill's own negligence as an affirmative defense, and we are in a contributory negligence jurisdiction. What happens? If Jack successfully proves Jill's contributory negligence in a jurisdiction using the traditional contributory negligent rules, what do we get? Jill recovers nothing because of her contributory negligence. Jill recovers nothing because she was more negligent than Jack. Jill will recover nothing if she's more negligent than Jill. Jill and Jack will split Jill's damages equally. Well, let's do a process of elimination. We know them splitting equally doesn't sound like anything that we've just talked about. So let's get rid of that. We know Jill will recover nothing if she's more negligent than Jill, right? It's a matter of just being intentional in your reading, right? We don't even have a defendant. So we know it's not C. Jill will recover nothing because she's more negligent than Jack. Well, there's nothing to indicate that she's more negligent, right? From the facts, there's nothing to indicate. Stay in the closed universe of the facts, right? Don't expand the universe. Stay in the closed universe of the facts. So the answer would then necessarily be A. What are your thoughts about contributory negligence? Too harsh? Not harsh enough? Should be harsher? I don't know. What are your thoughts? Think about it. If you want to bring something up during the next class period, you'll have plenty of time to do so. But that concludes January 11th's lecture. Please make sure you read the next case, which is the Coleman case, because that is going to introduce a rebuttal to this very harsh doctrine of contributory negligence. Thank you all for the opportunity, and we are done for today.